Bismillah ar-Rahman ar-Rahim. Assalamu alaikum. And on behalf of the Center for Islam and Global Affairs, CIGA, welcome to day 28 of the Ramadan webinar series. Today is Thursday, May 21st, 2020, and the 20th day of Ramadan, 1441. My name is Buthaina Hamda, and I'm a non-resident research associate at CIGA. I'm pleased to host today's session titled Challenging Injustice in the U.S. and Palestine, a Legal Approach, with Professor Noura Ariqat. Professor Noura Ariqat is a human rights attorney and an assistant professor at Rutgers University, New Brunswick Department of Africana Studies. Her research interests include humanitarian law, refugee law, national security law, and critical race theory. Professor Noura is the author of Justice for Some, Law as Politics in the Question of Palestine. She is a co-founding editor of Jadaliya Ezine and an editorial committee member of the Journal of Palestine Studies. She has served as legal counsel for a congressional subcommittee in the House of Representatives, as a legal advocate for the Badil Resource Center for Palestinian Refugee and Residency Rights, and as the national grassroots organizer and legal advocate at the U.S. campaign to end the Israeli occupation. Noura is the co-editor of Aborted State, the UN Initiative and New Palestinian Junctures, an anthology related to the 2011 and 2012 Palestinian bids for statehood at the UN. More recently, Professor Noura released a pedagogical project on the Gaza Strip in Palestine, which includes a short multimedia documentary, Gaza in Context, that rehabilitates Israel's wars on Gaza within a settler colonial framework. She is also the producer of the short video, Black Palestinian Solidarity. She's a frequent commentator with recent appearances on CBS News, CNN, Fox News, NPR, among others, and her writings have been widely published in the national media and academic journals. Welcome, Professor Ariqat. Thank you for joining us, and thank you to our audience for joining us. Professor, the floor is yours. Professor, to unmute yourself.
Okay, I'll start over. I thought I unmuted already. Assalamu alaikum. Thank you, Buthaina, for that generous introduction. Thank you to the Center for Islam and Global Affairs for this remarkable series. I'm number 27, it sounds like, in the series, or number 28 as it's rounding out. So I'm very honored to be a part of this. Thank you to Dr. Sami Al-Aryan, who I continue to look up to, and in fact, whose life and work is instructive and is even part of my curricula in the classroom. So both in struggle and in instruction, it's an honor to be able to work with you. I've been invited to discuss what does the legal challenge look like, and what can legal advocacy look like on behalf of Palestinian rights in the United States and elsewhere. And I thought it was the perfect, opportunity to be able to again discuss my book project, Justice for Some, Law on the Question of Palestine, on how I approach the question to law. So let me start by telling you where I begin this question, where I think many people begin this question, where I, at some point very early on in my activist career as a student activist at UC Berkeley in 2000, at the beginning of the what's known as the Second Palestinian Intifada, or the Al-Aqsa Intifada, I was studying in Palestine. I was actually an exchange student at Hebrew University when the Intifada begins, and it's something that changes everything for me. Even though I had already been committed, I was already a junior in university, I was already studying abroad, but there was something dramatically different that I couldn't identify then of why the Al-Aqsa Intifada would be a significant juncture. I was more or less removed from my study abroad program and returned to UC Berkeley, where I was studying and launched with the Students for Justice in Palestine, the first divestment campaign before the movement had consolidated in 2005 in the BDS call with the three-part principles of demanding a right of return for the Palestinian refugees, meaningful equality for the Palestinian citizens of Israel, as well as the end of occupation to all Arab lands, including the Syrian Golan Heights. We in 2000 launched a campaign at Berkeley in 2001, on February 6, 2001, on Ariel Sharon's second election as prime minister, and basically called for the divestment from Israeli apartheid on February 6, 2001, and we began a series of campaigns on the campus, from erecting a mock checkpoint, taking over a university hall in the middle of midterms in order and locking it in order to demonstrate the inconvenience of occupation to the students, building a refugee camp, a mock refugee camp on campus, and so on and so forth. Our activities created a ripple effect nationally that, many other divestment campaigns sprung up. There was a lot of attention to the protests that we were creating. We were changing the discourse. It was no longer about occupation, but we were making it about apartheid. It was no longer about Palestinians having to answer, why are you so violent, but instead turning the table on having Israel have to respond, why would anybody charge you with apartheid, as early as 2001. And despite all our efforts, nothing on the ground had changed. And it was part of that frustration, as combined with youthful naivety, that I applied to law school. And I thought to myself, well, activism is not going to change the course of history, or so I thought, that activism was not going to change the course of history or these, the reality on the ground. But if I went to law school, then if we can just use, have a judge and listen to us, and our arguments are better than the opposition's arguments. In any ways, we've studied them in ways that they have not studied us. If we had just a fair chance and a fair arbiter, we would be able to then liberate Palestine using the law. And, I obviously say that with a lot of, skepticism and sarcasm, because it's the farthest thing from the truth. Going to, entering into law school exposed me to the entirely new realm of what the law means, right? We have an idea and a conception that the law somehow imbues noble and lofty goals that transcend politics. But in fact, what I found in the course of my legal education was that law and politics are intertwined. To the extent that they were intertwined, I had not figured that out yet. But I knew that there was an entwinement between them. And I got a taste of that in law school when things as basic as alleging that, and I'll tell you exactly in a moment that it happened, I wanted to figure out how to use the law in order to vindicate the 2002 Israeli operation into the West Bank, and specifically the siege of Jenin refugee camp and the bombardment of the Jenin refugee camp in order to then take down the resistance there. And in my first attempt to think through a paper about a legal strategy of how to hold Israel to account for war crimes, indiscriminate shooting, disproportionate attacks, excessive use of force, and so on and so forth, things that would rise not only violation of the laws of armed conflict, but also grave breaches of the Fourth Geneva Convention, which regulates occupation and the treatment of civilians under occupation. It was in that moment that one of my favorite professors, who absolutely believed in what I believed in and supported my work, asked me to first establish how and why we can apply the Fourth Geneva Convention to the occupied territories, right? The most basic question, something that we take for granted. The Fourth Geneva Convention applies to occupied territories. The West Bank, including East Jerusalem and the Gaza Strip, are occupied. What more is there to show? And yet what was unearthed for me in that moment for the first time was there was an entire literature around whether or not the territories are in fact occupied. And it was a total legal question that one had to take seriously. And I that was the critical seed of inquiry that was planted for me, but not one that I nourished very much, right? I answered it enough to finish the paper, but once I finished law school, I got a fellowship in order to actually sue Israeli officials in US courts under the Alien Tort Statutes. And we sued Moshe Ya'alon and Avi Dichter in 2005. Moshe Ya'alon for his role in what's known as Operation Grapes of Wrath, which is a 1996 operation into Lebanon, where the Israeli army targeted a UNIFIL compound in the south of Lebanon, in Qana, where civilians had taken refuge, and they killed, with drone technology, 100 civilians in that single operation, and yet had not been held to account. And we brought the case against Moshe Ya'alon in the DC District Court under the Alien Tort Statute for that operation. We also sued Avi Dichter in the Southern District of New York for his role in the 2005 razing of 5,000 homes in Rafah, for, again, under grave breaches of the Geneva Conventions and many other laws that I won't get into, but I'm happy during Q&A. This was the moment that I felt my entire law school education and my efforts were vindicated, because this is what I wanted to do, which was to sue Israeli officials for war crimes, for these crimes against humanity. And yet within less than a year, both cases were dismissed. They were never heard on their merits. They were never, which meant that the judge never even let the survivors tell their story. They were dismissed on non-justiciability grounds, on grounds that said this was either a political question doctrine, which meant that it was better suited for another branch of government and not for the judicial branch, but instead for the legislative or the executive branch, and under the Foreign Sovereign Immunities Act, which says that you cannot sue a state, a foreign state, in U.S. courts. Obviously there's exceptions to that, and specifically under the Flatow Amendment, which allows you to sue what the states that the State Department designates as state sponsors of terror, and Israel is not designated as one of those states. And so within less than a year, both lawsuits were dismissed on non-justiciability, and it enhanced this question in my head that my professor in law school, Professor Buxbaum, had planted for me was, what is the relationship between law and politics? And what does it tell us about the Palestinian struggle for liberation? I was still stubborn and wanted to continue to try to use the law on behalf of, to advance the Palestinian struggle for freedom. And so after those two cases were dismissed, I began to do, strategic research, which meant that I was studying other jurisdictions in the United States that might be more favorable to our complaints. And the idea was that the judges in the Southern District of New York and the DC District Court were conservative, but perhaps if we moved to a different jurisdiction in the Ninth Circuit West in the United States, that they would become more favorable. What I found in the course of that research is that if I controlled for the variable of identities, right, the identity of those who are bringing the complaint, Arab plaintiffs, and the identity of the defendants, basically Israeli officials, what I found is that the same political hurdles did not impede similar lawsuits against Filipino officials, Serbian officials, Chinese officials, Guatemalan officials, West Papuan officials, and that what I could show is that this wasn't about the political question doctrine or the Foreign Sovereign Immunities Act, but in fact what this was about was protecting Israel in US federal courts. And what had initially been my strategic litigation research to file the next lawsuit became my first law review article that I published. And still I continued even as I was answering and exploring this question about the relationship between law and politics, still I continued to try to use the law to advance the Palestinian struggle for freedom. I worked on behalf of a Palestinian NGO on Badil for Palestinian refugee and residency rights on their behalf at the United Nations. I joined a legal delegation to the Gaza Strip in 2008 to 2009 in order to advance, to lobby the United States to end arms sales to Israel, both based on US law like the Arms Export Control Act, as well as international law. I went to the United Nations, to the Human Rights Council, tried many, many times until, and in every instance, right, the political impediments to these legal challenges stopped our attempts in their tracks, until the question about what is the relationship between law and politics became so burning and so overwhelming that it sent me back to school. It sent me back to school. And the culmination of answering that question about what is the relationship between law and politics and what does it tell us about the Palestinian struggle for freedom culminates in the book that we're discussing today, Law, Justice for Some, Law on the Question of Palestine. So the book is a culmination of about 15 years of actual advocacy and study in order to answer these questions. So let me tell you briefly how I answer them. On the first count, the relationship between law and politics. So I begin by telling you that one way to understand the law is to take it at face value, that it's somehow lofty, it's noble. You know, when we say Israel is not above international law, or Israel must comply with human rights norms, we mean something by it. It has a particular normative meaning that we're implying. But the truth is that there is no meaning, there is no concrete meaning to the law. And we can see that very evidently by the fact that here we have, right, decades of UN resolutions that have not shaped state behavior, that have not either commanded state behavior or punished transgressions of that particular law. So, and the fact that in all my advocacy, nothing yielded a particular outcome should tell us that the assumption that the law means something on its own is frankly just naive and not true, right? But on the other hand, the other extreme of this is the realist approach, which says that there is no such thing as law, that it's a political fiction, and that right is or might is right, right? So that the law is basically a political fiction, what Richard Falk once described cynically as a club with which to beat weaker adversaries, right? This is the idea that the strong get away with what they can do and the weak endure what they must. But in my research, I found that that wasn't true either. If it was true that basically might is right and the strong states get away with whatever they want, then how does that explain how the Palestinian Liberation Organization advanced some of the most significant strides in the Palestinian struggle for freedom through use of legal advocacy in the law? Particularly in 1974, the PLO advanced with partners advanced resolution 3236 and 3237, which established the Palestinian status as a juridical people or a political community with the right to self-determination, and that the PLO was the sole and legitimate representative, which meant that they were a nascent sovereign with the right to self-determination. They advanced in 1975 resolution 3379, condemning Zionism as a form of racism and racial discrimination as part of the decade against racism that was targeting apartheid. They advanced in 1977, between 74 and 77, with the non-aligned movement, that guerrilla fighters are not criminals or terroristic, but that they are soldiers and combatants. And they actually established that as international law in the additional protocols first additional protocol and the second additional protocol, and the first additional protocol elevated the status of guerrilla warfare, national liberation warfare, to actual combat, and recognized it as something that can be regulated. If we accepted that Mike was right, how do we explain these advancements by the PLO, which is a non-state entity facing off against the 11th most powerful military in the world, the only nuclear power in the Middle East, the United States self-proclaimed most significant ally in the Middle East? That wouldn't make sense. And so here you have these two extremes. On the one hand, the law is some noble, lofty aspiration that we can aspire to and use almost as a basis of principles, which is not true. And on the other hand, that might is right, and that the law means nothing and it's a political fiction. And I land somewhere not in the middle. I'm much more close to the realists, but a little bit here, just to the left of the realists, because it's true that law is politics. Law is politics, but it can be used in the service of liberation struggles, and it can be leveraged for its emancipatory purposes if it is used in the sophisticated service of a political movement, right? This is the tenet of movement lawyering. And movement lawyering is the belief that it's actual movements who are changing the course of history, and what the law does is simply serve movements as a tool. You can use it as a tool, but it can't be what guides your movement. It can be what serves your movement. So how can you, the analogy that I use in the book to help you think about this, think of the law like the sail of a boat. If you were in a boat, you cannot move without a sail. But the sail alone will not determine where you move or how you move. That direction is determined by the wind. And the wind is the political movement, right? So the sail of the boat is the law, the wind is the political movement, and I advocate wreck the sail when useful, when the political movement and the balance of power and our advocacy makes it possible to advance the cause using that sail, using that law. Draw it when harmful, when the political winds are against us, and create a new sail when possible, as the PLO did throughout the 1970s. So that was the first question, how I answered, what is the relationship with law and politics? So what does it have to do with the Palestinian struggle for freedom? Here, what I do in the book is I go back. I begin the book in 1917. And I begin it in 1917 because that is when the Balfour Declaration is issued. And not just because I don't think that's when Palestinian history begins, but that's when we see the relationship between law and politics begin and something very significant happen. Most narratives begin the story in 1967 as the onset of Israeli occupation of Arab lands, and if you're really sympathetic, narratives will begin in 1948, which marks the forced removal of Palestinians and their forced exile. But what we miss when we begin in 48 is the 3 decades of British imperial sponsorship of a Zionist movement that actually created the conditions that made the Nakba possible, and that laid the foundation for what has now been Israel's domination of Palestinians onwards, all the seeds for the racial tropes, the colonial legacies, the legal tactics that Israel uses today were actually developed and planted in the interwar years between 1917 and 1945, right? And so I begin in 1917, and what I show is that the Balfour Declaration, which is very, very short, right? It's a letter that promises the Zionist movement that they can establish a Jewish national home to be distinguished from a Jewish state. And that distinction is significant because the state would mean that there was conspiracy from the beginning for the British to establish a Jewish state in the place of Palestinians, but that wasn't true. The British, as an imperial force in the world and a mandatory power was interested in maintaining its influence in the Middle East, in maintaining a foothold and access to geopolitical resources, and actually competing with the French for domination. And so their greatest interest was to impede Palestinian independence so that they can maintain their presence in the Middle East. And it was also to impede, they didn't want a Jewish state, but wanted to have a reason to continue to intervene in the Middle East, and having, protecting a minority in the Middle East would be part of that approach. So the promise of a Jewish national home was the promise of a cultural Mecca that wouldn't culminate in independence. Now, that's one. The other thing that for me that was most significant in the formulation of the Balfour Declaration was in the promise of Palestine for as a site of Jewish settlement, to establish a Jewish national home. The Palestinians, who are at this time 90% of the population, are referenced in the negative. They're discussed as non-Jews, not even as Arabs, not even as natives, but as non-Jews. And the Balfour Declaration recognizes that they're there, but discusses that, but only promises that their civil and religious rights will be protected, but not their political rights. And the reference to them in their negative, together with the protection of their civil and political rights, civil and religious rights, but not their political rights, is what I describe as a colonial erasure that negated the juridical status of Palestinians as a political community, as a people with the right to self-determination. Instead, they were regarded in that moment as an Arab minority who could be settled anywhere, and if they remained, they can have the right to civil and religious rights, but never to the right to self-determination as a people. And that juridical erasure was established through a form of exception to the law, which meant that, and I don't want to get too much into the theoretical discussion about the state of exception and what it means, but suffice it to say that what I advance is that exception to the law is achieved by insisting that there is a unique fact pattern, sui generis, unlike anything other, which justifies the establishment of new law where the sovereign exists, where the sovereign insists that none existed. So if, for example, take this as an example. If you get into a car accident, usually there could be some sort of law that advances, well, what law should apply in order to remedy the conflict that you're experiencing in the car accident? Well, if the person that you're in the car accident with says that there's never been a car accident like this before, there's never been a street driven like this street before, then we can't apply existing law to this situation. We have to create new law in order to settle our claims. That would be a sui generis fact pattern. And that is the way that the question of Palestine has been regarded, as sui generis, as an exception. But the fact pattern in Palestine made it different than all of the other Area A mandates or the former Ottoman empires that come under mandatory rule in the aftermath of the First World War, so that Palestine, unlike Transjordan, unlike Iraq, unlike Lebanon, unlike Syria, will not be ushered into independence through the trusteeship of mandatory powers, but instead will be set apart. And the unique fact pattern that the British advanced was that Palestine should not come under any national authority, but should be governed internationally because it's the site of religious significance to the three monotheistic religions. And this is the logic that guided what we see in 1947, what guides the separatist, the Corpus Separatum, which establishes that Jerusalem and the partition plan and UN Resolution General Assembly Resolution 181, that Jerusalem wouldn't come under any national jurisdiction, but instead will be governed through some sort of international arrangement. That's the same logic that culminates in 47. That's one. Number two, the exceptional fact pattern is that this should be used, that the Palestine mandate should be used as a way to help resolve an age-old, what's known as the Jewish question, or the exclusion of Jews from Europe, from meaningful equality and inclusion, where Jews are treated through Orientalist tropes as outsiders, are racialized as inferior, as non-learned, as in many racial tropes as not worthy, and are actually denied citizenship in Europe in many contexts. And the third is just very racist, that Palestinians can't govern themselves anyway. These are a bunch of Arabs, right? This is developed in a context where most of the world's population comes under imperial domination and is denied the right to self-determination. And so those three things together constitute what is a unique fact pattern. And Lord Balfour captured this more or less in 1919 when he says Zionism, be it right or wrong, is far more noble than the current whims of some 700,000 Arabs. And this is the unique fact pattern that allows this exception, that unlike any of the other mandates that will be ushered to independence, the Palestine mandate will have a different future. That exception, okay, is precisely what, and the juridical erasure that it establishes of the Palestinians as a people is precisely what Palestinians have fought against for 100 years. For 100 years. And in the course of my book, I use 5 historical junctures in order to document how that exception is reified, how it's resisted, how Israel is using the law to advance its settler colonial interests, and how Palestinians are resisting that. And so let me just briefly tell you how I do that and what the point of it is. And I'll start with the point. Lawyers always start with the point, although, I'm a legal academic, but let me start with the point so I don't make you wait. The takeaway is that in the course of 100 years, what I find is that the closest that Palestinians ever come to overcoming this exception and to challenging their erasure and to establishing the right to self-determination is when they actually challenge the geopolitical structure that sustains the exception, which means they are challenging the balance of power that sustains this unique fact pattern. When have Palestinians done that? 1936 to 1939 in the Great Revolt. And after nearly 2 decades of trying to use the law to challenge Britain's violation of the League of Nations covenant for the mandates, which are all futile, right? Palestinians try to argue how Britain was violating different articles of the League of Nations Charter to say that you are not fulfilling your obligations to Native peoples to usher them to independence, failing, and British would acknowledge it, but say that the Palestine mandate was exceptional. It was sui generis, right? Palestinians then come closest to displacing that British policy during the Great Revolt, when in the aftermath in 1939, the British issue the White Paper. And the White Paper, the 1939 White Paper is basically admitting, the British admit that their Zionist policy was wrong. And they suspend, unfettered, they try to limit Jewish immigration, and they try to limit land sales. So that was the closest, but then directly afterwards, World War II begins, and whatever advancements that the White Paper made are stunted, and what we see afterwards is basically the beginning of Palestinian removal, beginning in December 1947. So that's the closest they come, but they also come incredibly close in the 1970s, as I mentioned, when they are together with the third world upheaval, challenging imperial domination, establishing that Israel is an imperial power akin to the United States and Vietnam, to Portugal and Mozambique and Angola, akin to apartheid, South Africa and Southwest Africa. And they come close again in the second Intifada, what's known as, known as the first Intifada in 1987, which then culminates in the Oslo peace process. Those have been the closest times Palestinians have come to challenging the geopolitical circumstances that sustains the exception surrounding the question of Palestine, setting it apart from all other similar settler colonial contexts and basically apartheid situations. So that's the takeaway. That's the lesson learned. But the way that I organize the book, as I said, in 5 junctures, are all organized by moments when political circumstances made it up for grabs of how you can advance, how you can now use this new context in order to advance legal interpretation or legal meaning, right? These are legal opportunities to change the meaning of law. And each of these 5 junctures is precipitated by some sort of confrontation, mostly a military confrontation. So the first juncture is 1917, and in that juncture, it's the Balfour Declaration, it's World War I, and then the Balfour Declaration through 1966, and there it's a 50-year period where I basically cover the history, right? Everything that now, if you read that first chapter, those first 50 years, it's almost like you can read the next 50 years that they then chronicle in the rest of the book. But it goes from the Balfour Declaration, the Great Revolt, the Arab-Israeli War, the establishment of Israel, and culminates in Israel's establishment of an emergency regime, which is a regime of permanent racialized governance over the Palestinians that remain, the 160,000 or so Palestinians that are not removed, who become the Palestinian citizens of Israel, upon whom basically what occupation law is applied to them before it's applied to the Palestinians in the West Bank and Gaza. In chapter 2, I begin in the 1967 war. And there I show kind of what I was telling you in the beginning. It's not that Israel has advanced its settler enterprise in the West Bank in violation of international law, right? We always say this is a violation of Article 49, subsection 6, which prohibits the transfer of an occupying power's civilian population into the territory that it occupies. And Israel's continuing settlement project is a grave breach of the 4th Geneva Convention and is a war crime. Yes, we can make that argument. But Israel has been advancing another argument under international law that has made its settlement enterprise possible. And so what I show in chapter 2 is that Israel has not advanced its settlement enterprise in violation of international law, but based upon international law. Without the law, Israel could not have expanded and entrenched the settler colonial enterprise that it now has in the West Bank, which it now is proposing to annex unilaterally. In chapter 3, it is the 1973 war. And then the 1973 war is significant because that is when Egypt and Syria win the battle but lose the war. But in the course of that, come closest to demonstrating that Israel is not infallible. And more significantly, what we learn in that moment is that neither Egypt nor Syria will wage a conventional total war of liberation, and that Palestine will not be freed through a military confrontation. That is the moment that we also understand that in the aftermath of the 1973 war, we learn that it is also what precipitates what becomes the Middle East peace process that is advanced and engineered by Henry Kissinger, who is both a National Security Council advisor, director, as well as the Secretary of State at the time, And what Henry Kissinger does in this moment is to disaggregate the Arab-Israeli question into bilateral questions. So it becomes the Israeli-Egyptian peace process, the Israeli-Syrian peace process, the Israeli-Lebanese peace process, the Israeli-Jordanian peace process, of course, the exclusion of the PLO. It's this moment that we see the PLO advance its most fervent legal advocacy at the United Nations, where it achieved the greatest accomplishments I mentioned to you. But it's also in this moment that we see a split within the PLO, one that wants to continue until total liberation of Palestine, and another that begins to contemplate the establishment of a Palestinian state in the West Bank and Gaza as either an interim or a final status solution. So we see, normally we think about Oslo as, the major juncture, but those seeds for a two-state solution are planted actually is in the late 60s and the early 70s within a branch of the PLO, what's known as the pragmatic front as opposed to the rejectionist front. The fourth juncture is the 1987 Intifada, which culminates in the Oslo peace process, and we see the conflict, the split between the PLO that we see throughout the 1970s. We see that resolved in the course of the Oslo peace process, where there's agreement. There's agreement within the PLO and the PNC that governs it, the Palestinian National Council, in order to establish a Palestinian state as an interim or a final status solution. It's in 1987, we see the Palestinian Declaration of Independence that's written by Mahmoud Darwish and translated by Edward Said. And this is not a treat. The shift to a two-state solution is not treasonous, right? But what is, and what's really problematic, because it was seen as a possible pathway to freedom. The idea of two states is not the problem. It was the Oslo structure itself, which is the problem. And Oslo basically sets up that a new exception where Palestinians will not enjoy independence, right? And so what I show in chapter 4 is not how bad Oslo is, right? And Oslo not just referring to the Declaration of Principles of 1993, but to all of the subsequent agreements and leading, through 2000 and its collapse after the Camp David talks. What I show in that chapter is not how bad it is by translating the legalese, because upon reading it, you don't need to be a lawyer. You just need to be literate to know how bad it is. There's not even a promise of Palestinian statehood or independence anywhere. It's an autonomy agreement that reflects the 1978 Middle East peace process framework between Anwar al-Sadat and Menachem Begin, where Palestinians will enjoy autonomy, but never sovereignty or independence, right? And so what I try to show there is not how bad it is, but why. Why did the PLO enter into that agreement? And how did Israel achieve that and achieve that consolidation? Leading up to the final chapter, chapter 5, which begins in 2000 and the collapse of the Camp David talks. And there I show how Israel planted the seeds in the course of what becomes known as the Al-Aqsa Intifada, where I also started the story. Israel plants the seeds in the course of the Al-Aqsa Intifada when it takes responsibility for extrajudicial assassination of Palestinian political and military leaders. Israel has always used assassination as a policy, but it always denied it. And what happens in 2000 is it begins to take responsibility for it and justify that they can use that. And they call their extrajudicial assassinations targeted killings. And I show how the seeds they planted in the course of the beginning of the second or the Al-Aqsa Intifada basically become seeds for new laws of war that we see come to lethal fruitions in the course of systematic and deadly campaigns against the Gaza Strip through 2000, frankly through the present, but in the book through 2014. So that by 2014, when Israel, in the course of 51 days, launches 6,000 airstrikes using 50,000 artillery shells, displaces a third of the Palestinian population, internally displaces them, destroys 18,000 homes, kills 2,200 Palestinians, some 534 of whom are children, right? And to date, Israel has never been held to account for that register of death and destruction. And it's not because, and I argue, it's not because Israel got away with it. It's because Israel has advanced new laws of war that argues everything that it did was legal, that they could do it again, and that other states can do it too. So that's where I end. The junctures anyway, but in the conclusion, what I do in the conclusion is use all of this to set us up for new questions about the future. And so let me just summarize that for you. And for those who are interested in looking at the book, obviously I like the book, and any writer enjoys the learning process, but the conclusion is my favorite part, because the conclusion is where I shift my thinking away from just the relationship between law and politics to thinking about freedom, and to thinking about how is it that we will get out of our trap. I end the book by establishing that what we are now, what Palestinians find themselves in now, is a sovereignty trap. And it's one that many indigenous nations have found themselves in, which means that in order to achieve a modicum of self-representation, that they have to prove their eligibility to the settler sovereign. But in exchange for proving their eligibility for self-rule, it means that they will always be under some perpetual domination and never experience independence. What does that mean for Palestinians? It means that since Oslo, Palestinians have recognized Israel, their settler sovereign, have renounced the right to use force, which was established in '77, but established that as a precondition, have rescinded the resolution declaring Zionism as a form of racism, and have now been armed, lightly armed, in order to police other Palestinians, to prove to Israel, and obviously its patron, the United States, that it can protect Israel from Palestinians. So Palestinians have been under the Oslo framework, part of the security apparatus to protect the settlements, to protect the settlers, to police Palestinians, to torture them, to kill them in some cases through security coordination in order to prove their eligibility. It's why we have seen time and again the Palestinian leadership rescind its challenges to Israel on the international scale, because of this framework of proving its eligibility, and always banking on the fact that the U.S. will somehow offer them a better negotiating position, and finally be able to deliver a Palestinian state. And we are now bearing witness. I wrote this in the book, and others have written it well before me. Edward Said wrote an article the morning after Oslo was signed, basically predicting this outcome. But now we see it. Now we see it in the culmination in the Trump administration's deal of the century and impending annexation. None of this is a surprise, but it was also not inevitable, but it was very, very predictable. Very predictable. And so what I ask in the book is, how do we overcome this sovereignty trap? How do we get out of it? And, the three ways that we've known since 1947 is what the UN Special Committee on Palestine proposed in 1947, which was a federal state with strong protections for the Jewish minority, a federal Palestinian state with strong protections for the Jewish minority, a binational state for Jews and Arabs, as they were referred to as Arabs, and as a two-state solution, right? A Jewish state and an Arab state. We've known these three political possibilities since 1947, and yet have not been able to achieve that. And I didn't want to end the book by reiterating one of those. And instead, I ask provocative questions to help us get out of the sovereignty trap. And I draw on indigenous literature and Afrofuturist literature to think about not what is possible, but what we must make possible. And I do it by inverting our question of the right of return, that the right of return for Palestinian refugees should not be seen as the culmination of our freedom struggle, but should be seen as the beginning of it. We will not return to 1947, a Palestine of 1947. We are returning to the future. We are returning to Palestine of 2025, 2030, 2035. And the questions we must answer is, what will that Palestine look like? Palestine of the future look like? And what is it in that future that must be just for Palestinians? How will we make that future an optimal one for Jewish Israelis as well, and an optimal one that Israel has been able to offer Jewish Israelis? It's a big question, and it's a difficult question, but it's one where we're thinking about the future and building the future rather than thinking about the past. Our return is a return to the future. And I don't answer that question. I don't know the answers to that question. That's something that has to be developed organically and amongst Palestinians collectively. But I offer ways to think about how to answer the question, which is to offer how we can use racial frameworks and anti-racism, not just racism as dimensions of the Palestinian struggle for freedom, but what happens when we think about Palestine as an anti-racist struggle. How does that complicate the bifurcation, the native settler binary that distinguishes Palestinian natives from Jewish Israeli settlers, and instead bring into focus for us, right, Afro-Palestinians and Afro-Israelis, that brings into focus for us Middle Eastern Jews within Israel and how they have been subjugated and racialized as a racialized minority that's also stratified as inferior vis-a-vis European or Ashkenazi Jewish Israelis, right? And so how does our contention with that reality also open up new frameworks for us to think about what we can do in establishing that future? And those are, so I basically end the book on that question, and I say there, and I'll say it again, in the course of answering this question for ourselves, Palestinians will not only be advancing our own struggle for freedom, but we will be answering a question for all liberation struggles throughout the world, not just Palestinians, but for all peoples struggling to be free. And again, affirming how Palestinian is a cause, how the Palestinian cause for freedom is a cause for all of us. Thank you.
Thank you so much, Professor Noura Ariqat. This is a lot to take in. I appreciate both the overview of your book and your insightful articulation of it. So for those of you just tuning in, we're here with today's segment of the CIGA webinar series featuring human rights attorney, professor, and activist Noura Ariqat. Now, if I may, I have a few questions myself, but as I'm looking through the questions that are being submitted through the portal, a lot of them are concerned with the particularities of the law, so I'll reserve my questions because I think that they're kind of addressed in the ones that are being submitted. But I think my questions sort of deal more conceptually about international and human rights law, decolonial thinking, and as it enables activism, if you will. So I'd like to kind of focus a bit on that, if I may. So you offer an intersectional approach to studying the law and advocating for the Palestinians as informed by other struggles, as you mentioned, drawing on other literatures and thinking about Palestine in terms of the anti-racism struggle and framework. So I think given that we have an international audience, I'd like to just specifically define intersectionality and its origins. So the formal concept of intersectionality was coined by American lawyer and critical race theory scholar Kimberly Crenshaw in the late 1980s in her legal analysis of anti-discrimination cases involving Black women. Black women, she argues, encounter a more unique form of discrimination against neither their Black nor woman identities exclusively, but rather an intersection of their two identities. So before the law, Black women didn't have a case because they had to either choose between being Black or being a woman. They could not litigate as Black women, specifically who face overlapping systems of discrimination. Therefore, advocacy that rests on what she refers to as single axis or single issue frameworks, such as the Black anti-racism movement or feminism at that time, as it was dominated by white women, alone are insufficient for accounting for their experiences. So intersectionality then developed into an analytical framework, as Crenshaw describes it. And intersectionality has since then moved away from just identity-based framework to primarily critique of structural power. Now, intersectionality has components of both theory and practice. This means that many Western activist movements have adopted intersectionality as a framework of analysis and as a foundation for building solidarity movements across multiple causes. So if you can just bear with me, I have a few intertwined questions for you, Professor Noura, concerning the adoption of intersectionality. First, my question would be, is intersectionality a solidarity-based framework or a liberatory one? Can we truly rely on intersectionality to liberate Palestine? And here's why I ask this. I've read an article by Jaquit Singh, who, in his article, Religious Agency and the Limits of Intersectionality, and he writes that intersectionality is not a freestanding critique or framework of analysis. He says, quote, "Indeed, oppression can itself only be identified, understood, critiqued, and resisted from it within an ethical political tradition, and against a background horizon of meanings, goods, and purposes. Ethical political difference actually modulates the nature and character of oppression and the appropriate responses and resistances to it. It shapes what will be regarded as oppressive in the first place, in what specific ways it's experienced as oppressive, and how oppressive social structures or relations should be resisted," end quote. So in other words, there's no all-inclusive consensus on oppressive subjects or oppression. It's not enough just to be anti-oppression. Of course, that's necessary, but it's just not, it doesn't go far enough. So I guess I'd like to extend this to the case of Palestine, in which we find Palestinians also grappling with particular ethical commitments. Let's take, for example, religiously conservative Palestinians who really believe in Palestine and the struggle for Masjid al-Aqsa as a religious cause. How do we reconcile viewpoints on the nature of the struggle of Palestinians, those who might consider the struggle as a primarily religiously oriented one, or those who might consider it more from, for lack of a better word, the secular worldview? And then just another example of what I mean, just so my question is clear, and then I'll stop there. And of course, I'll allow for more time for the questions being submitted. But as just another example, let's take the case of the US Women's March. That was initially lauded as an intersectional effort. And yet several women resigned or were otherwise dismissed from their positions within the march due to their stances on Palestine. Does this, to you, indicate a potential failure of the intersectional approach in this context, or do you think maybe it was a failure of something else? So I hope these questions make sense. So it was very loaded, but I'd like to hear your thoughts.
Thanks, Busaina. So you're basically asking three different questions in that formulation. So let me parse them, okay? One is, I appreciate the lifting of intersectionality, but I want to be clear that even though, you know, a lot of the way that I end the book is thinking through our collective liberation is informed through an intersectional approach, the legal strategy that I'm advancing is very much one that's lifting up anti-colonial legacies. So, you know, what does it mean to be, you know, when the approach to the law and to the legal strategy and how to use it, and how to use it on behalf of colonized peoples, on peoples who are not represented by a state, on peoples who have been denied a state, on peoples who are not recognized as a people, right? On this is all part of an anti-colonial, anti-imperial legacy, right? That's where it is firmly. And the other thing I want to clarify is that intersectionality, before it's coined by Kimberly Crenshaw, is coined by another woman named Frances Beale, who articulates, you know, the condition of Black women as being double, in her article on double jeopardy, right? Because you cannot capture the experience of oppression either through just womanhood or through Blackness, but instead a combination of those things that we can't capture. And it also comes to fruition in what Black radical women offer us in the Combahee River Statement, when they explain to us also the political economy of that gendered racist approach, when they show us that, and this is the most telling example, that even when you think about slave economics, that the systematic rape of Black women who were enslaved actually produced more profit for slave owners because they owned their offspring, right? How you capture that violence. And that's where, so this is what intersectionality is offering us, that these things cannot be disentangled as we think about them. Okay, so that's just, thinking about what intersectionality is historically in the form of activism and resistance, conceptually, as you mentioned, through Kimberly Crenshaw, and what comes, in what we see today being practiced, which is this, everybody uses it, right? Everybody uses intersectionality in order to explain why it is that we are uniting politically, which is a political choice, right? So the way that I would urge the audience to think about intersectionality is not necessarily as, just as something given, but as a political choice that we make when we choose to engage in solidarity politics, right? Somebody told me this once when they, in a lecture last year, she was part of the PLO, cadre and guerrilla fighters, who says what this generation today calls intersectionality, we in the 1970s just called it solidarity. All right? So intersectionality is not meant to limit us. It's meant to expand our potential, right? And so adopting this approach basically means that I believe that I cannot be free unless you are free, right? And it's making a connection between settler colonialism the world over, racial oppression the world over, imperial domination the world over. And it's making clear that those things, that even though our issues are very distinct and very particular, have different legal articulations, that they are entwined because of the various intersecting axes that we experience, and we can identify a common oppressor. But what's the most powerful thing about it is that it is making us, the many and the weak, in our solidarity, into the strong against the few. So that's one. Number two is I think, then there's you asked about the religious question, and the third will be the Women's March, just so folks know what I'm answering. I think that the question on religious dimension and how people approach the question of Palestine has nothing to do with intersectionality, in my opinion, right? Even without that framework, this will be an enduring issue. For some advocates, they see this issue and as a Muslim issue. This is about protection of Al-Aqsa. This is about protection of holy sites, right? And so this has resonance in a pan-Muslim approach to the question of Palestine, versus a question that sees it as an Arab issue of Arab nationalism, that this is about the liberation of Arab lands. This is about an anti-colonialism and a process, a struggle that is an actually unfinished business of Arab anti-colonialism and anti-imperialism. And you can still have yet other ways, of advancing these causes. That conflict of how you approach it, one, doesn't need to be a conflict. But two, isn't a matter of intersectionality as far as I'm concerned, but is a matter of political choice. Again, Arab nationalism is not a given. Many people will tell you what unites Arabs. Geographically, they're distinct. Culturally, they're distinct. Even though they speak Arabic, linguistically, they're distinct. Indigenous populations across these geographies is distinct. So what could they have in common? Frankly, it doesn't matter. It's not about proving sameness. It is a political choice to be aligned in that way, in the same way that when you adopt Pan-Islamism, you are making a political choice to identify in that way, right? And Dara Lee shows this brilliantly in his new book when he's thinking about global jihad and other ways that Muslims have conceived of themselves as part of a broader grouping, right? But these all reflect political choices that are being made. And his book, by the way, is called The Universal Enemy. These are all political choices that are being made. And so how you resolve that basically depends on the political choices that we make together. And then finally, about the Women's March. I've written about this before, and I think, the Women's March has its own history. It was initially about just vindicating the loss of Hillary Clinton because the country wasn't ready for a woman leader, for a woman president. It is protest in response to that very narrow womanist, what's known as a first wave of feminist approach of thinking about feminism that forces the Women's March founders to then bring on 3 women of color, Linda Sarsour, Tamika Mallory, and Carmen Perez, in order now to advance a more intersectional framework of feminism, which represents later approaches. That's a radical approach, a more radical approach to thinking about women not merely as women in our biological conception, but women who are facing poverty, refugees, or migrants who are facing colonial domination, who are facing racial terror, right? That is also part of a woman's platform. And I think that they did a great job in advancing that. And we saw a back and forth constantly going on. We saw resistance to the inclusion of Palestine in that framework. We saw protests to the inclusion of Rasmiya Odeh, a Palestinian freedom fighter who was part of establishing, advancing a framework of women's rights through an intersectional approach, that we see this conflict go on. And so what we see now in the resignation of the resignation and the exclusion, as Zahra Bilu was forced off, right, the campaign, wasn't inevitable either. It's the result of struggle and, frankly, the triumph of first wave feminists who have taken over the Women's March. And so we're now at a juncture where we can either say, well, we want to keep fighting until we can reclaim that platform, or we'll create an alternative ourselves, right? But that has been a site of struggle and conflict and advocacy, and nothing has been lost because all of that has been the politicization of people who might have joined this cause, but might never have heard about Palestine, and frankly, not just never heard about Palestine, but because of American exceptionalism, which frames the U.S. as distinct and somehow, the U.S. is the beacon of democracy. The U.S. is, where you should have your rights. It's this idea that the U.S. is unlike anything other, which negates that it's actually a site of racial terrorism since its inception, and a site of settler colonialism where it has expanded. It is an imperial project within our own borders against native populations. Most people who adopt American exceptionalism, for them, Palestine is as foreign as knowing about the US's role in the Philippines or in Puerto Rico, or its ongoing global war on terrorism and its violence against Afghanistan and Pakistan and Somalia, right? Or its ongoing intervention throughout the Middle East, its sanctions on Iran, its sanctions on Venezuela, its sanctions on Cuba. So what Palestine in the Women's March brings into focus is the dimension of a feminist struggle, not merely against poverty, race, and patriarchy, but imperialism as well.
Okay, thank you, Professor Noura. I might have to email you the remaining questions that I have just for the sake of time, because I'm still seeing questions come in and I'd like to allow them their time. So I'll go ahead and just ask 3 questions at a time, if that's fine, and then we'll try to get through as many as we can. So the first question is, in your experience, what are the needed criteria, if any, that victims of Israeli aggression and violence could successfully sue Israel or its leaders? The second question is, even when there are established laws, why does it matter seeing that Israel blatantly violates international laws with no consequences? The law provides a remedy, but the law is not being followed. So now what? Turkish military intervened in Qatar recently. Why not Palestine? A third question is, could Israel's supporters be successful legally in stopping the BDS movement in the US, or is it just political posturing?
Okay, great questions, thanks. The first one was?
Yes, so in your experience, what are the needed criteria, if any?
To bring, okay. So as I said, and I'm gonna combine the first and the second question, okay? Because the first question is, what do we need in order to have a successful legal claim? The second question is, why can't we apply the law? So these are very related. So again, I wanna reiterate, the law doesn't mean anything. It's not that Israel is violating the law and getting away with it. They are using the law to advance their interests. They have, in the course of the 100 years I cover, I show that international law has done more to help Israel and has been more beneficial for the Israeli cause of settler colonialism and expansion than it has been for Palestinians. And it's not a violation of it. It's precisely because the law has no set meaning, and because of its indeterminacy, that can only be, the meaning of law is only to be determined by the political winds. And on balance, the political winds have been in Israel's favor owing to its military prowess, owing to its relationship with the United States, owing to its advocacy globally that has created, Israel's Zionist settler sovereignty somehow immutable, right? That's why there's consensus on the two-state solution, because, and what that means, it's not consensus. When they say consensus on the two-state solution, it doesn't mean consensus on establishing a Palestinian state as much as it means consensus on maintaining Israel as a Jewish state, right? These are all things that represent the balance of power in favor of Israel. And Israel has used that to its advantage. Remember, the law is a sail. The direction that the law, the direction that the boat goes and how the law, what the law means and how it's applied is contingent on the political movement. And the moment that Palestinians have been able to advance the law in its favor was at the height of our political movement in the 1970s, when we aligned with the non-aligned movement, with the G77, with a third world upheaval against racial hierarchy of the international system, against neocolonialism, against colonial domination. That's when we see Palestinians able to use the law the most effectively. But there is no similar political movement today. So for the question of why isn't the law, applied in order to punish Israel? Because the law doesn't do that. The law can only be used as a tactic when political movements are making that possible. An example, the Palestinians have now filed a claim finally at the International Criminal Court, but they are depending on the proceedings of the ICC in order to somehow vindicate Palestinian rights. According to my approach and to my argument, Palestinians should be waging the battle of the ICC politically outside of the courtroom. They should be advancing the cause. They should be demonstrating Israel's criminality in the political and public space. They should be winning, right? They should be winning the case against Israel politically even if they are dealt a legal defeat within the ICC, which is very possible, despite everything that we're able to show regarding Israeli war crimes, okay? But the Palestinian leadership is not doing that. They filed the petition and done nothing to advance this as a political program, to build the advocacy campaigns that will basically define Israeli operations as criminalistic. Meanwhile, Israel's diplomatic corps is all over the world to get capitals and states to oppose the ICC bid, which they have done successfully. Especially among European capitals. So the answer to this question about what do Palestinians need, they need a political movement. They need a robust political movement. BDS, in my opinion, is a robust solidarity movement, but it's not a national liberation program. And it's not a liberation movement for Palestinians. That would require us to have a vision for decolonization. It is a human rights campaign that is asking solidarity activists to join, to believe Palestinians, and to overcome the diplomatic intransigence within their countries in order to have some opposition to it. A robust political movement would actually be a national liberation struggle with a vision. And as we've seen right now, the Palestinian leadership has no vision. We're on the eve of annexation, and the Palestinian president Mahmoud Abbas is basically threatening yet again to cut off security coordination with Israel and all ties to the United States, but has not made good on it. Those are empty promises. If he were actually to do that, if the Palestinian leadership were actually to do that, they would pivot away from the United States, which is absolutely necessary. They would build alliances with other states. They would annul Oslo immediately in order to do that. They would support, they would endorse as a Palestinian national movement boycott, divestment, and sanctions, but they have not. They only support boycott of the settlement enterprises, but not of the full scale, not for the return of Palestinian refugees. And in fact, have not pivoted away from the United States, but are just waiting for a better administration than Trump. So now we could still use the law, but mostly in a defensive posture. As Palestinians are being sued, we can still use the law for defensive purposes, but in my opinion, not effectively for offensive ones. Not without a more robust political movement. And then finally, what do I think about the campaigns against BDS? It's the jury is still out. It depends on whether or not we advance that cause. Is it possible that it'll be criminalized in the United States? It is possible, perhaps not in the way that it's iterated right now. Now we have 41 out of 50 states that have either passed or proposed anti-BDS legislation. We also have a bill in the Senate that's still in committee that hasn't been taken to a floor vote. Now, what I think will absolutely not happen is they can't criminalize BDS activity. Can they associate some civil penalties with it? Even if not in the law, as we've seen in certain successful lawsuits against it in Arizona and elsewhere, and now in Texas, even if not in the law, you can certainly see institutions internalize the preference against BDS informally, because they don't want the headache, they don't want the controversy, and they don't want the threat against its funding. So the campaign against BDS is in the beginning and will be very ugly. Here's what I'll say about that as we struggle through it. When we launched divestment in 2001, we were laughed at as being part of a fringe, as a bunch of, naive students who didn't understand how politics really worked and were just, using a bunch of protest movement. And now we see in 2020, right, what it's been, just about 2 decades, BDS become regarded by Israel as the second most significant threat to Israel after a nuclear capable Iran. And we see it as a presidential campaign issue. And we see it as legislation, something that's taking place across these seats. We've seen the ACLU get involved to protect the right to BDS, not because they believe in Palestinian rights, but because they believe this is a fundamental First Amendment right. And I say all this to say that what was once laughable is now the center of the political debate. But that wasn't inevitable. Struggle made that possible. And so it's going to be struggle that determines the future of what BDS looks like. And the thing that I'll urge people to do, I know it's very scary, but we're not going to win by hiding. We're not going to win by not participating in BDS campaigns, by trying to shield ourselves because we're afraid of, you know, of the repercussions that come with it. It's like all movements. We all win when we face off. They can imprison one of us. They can't imprison 100 of us, right? Like that kind of theory. So I urge you that the success of the movement is about choices that you make, and a choice to continue to take the risk, and a choice to be involved in it, and knowing full well that we are strong in our numbers, the many against the few, and that we should continue.
Okay, thank you. We have a little bit under 10 minutes remaining, so let me just try to get through a couple of more. So one next question is, would you be able to comment on the recent Mike Pompeo's threat to the International Criminal Court if it tries to have jurisdiction on Israel for its crimes against Palestinians? And next question is, it seems that
what's the question though? What about the Pompeo's threat?
Be able
like
to
real thing?
Asking for your comment on that. Recent Mike Pompeo's threat to the ICC if it tries to have jurisdiction on Israel for its crimes against Palestinians. Next question is, it seems that the evangelical Christians in the U.S. have a lot of sway in protecting Israel. Would Americans be able to sue the U.S. by not being able to separate church and state powers in relation to the U.S. and Israel? I think that might be the number of questions we have time for. So
really quick on the first one, the United States has always been opposed to the ICC, not just when it comes to Israel, but when it's come to its own jurisdiction. It never has not signed the Rome Statute of 1998, which basically, you know, the ICC is a product of a multilateral treaty. It is not a derivative of the General Assembly. It's established through a treaty to establish an independent court. The US and Israel never signed the treaty. Okay, the U.S. is afraid for itself because it doesn't want its military personnel ever tried for war crimes or crimes against humanity in an international tribunal. And so enters, under the Bush administration, enters into bilateral treaties with different countries that says, even despite your adherence to the Rome Statute and to the ICC, you'll never turn U.S. military personnel over to the ICC, but instead allow the U.S. to try them. Okay, the Obama administration does sign the Rome Statute, but we're not necessarily a party to the ICC. We are protecting our own, the US is protecting its own imperial interests, right? And it's not just the US. There aren't many states, strong states that support the ICC. And as we've seen since its inception in 2002, the ICC has primarily been a tribunal to prosecute African heads of state and one Serbian official. So, and it's why several African states have actually rescinded from the treaty itself and said that this is just a politicized body. The future of the ICC is at stake in this moment, and unfortunately on the lap of the prosecutor, Fatima Bensouda, because she is in a hard place. If she proceeds with the claim against Israel, right, then she is going to face a rescinding of funding, basically the death of the ICC, and not necessarily death by its destruction, but by making it irrelevant because of a lack of support from the strongest states. And on the other hand, if she doesn't prosecute Israel, what we're going to see is a very blatant, right? The very blatant politicization of the ICC as a tool only against the weak, but never against the strong, which will make it illegitimate in the eyes of the majority of the world's population. So Pompeo's opposition to the ICC is in line with historic US opposition to it. And now, frankly, also in line with opposition from Germany, from Norway, from several European capitals that also oppose it. But how it proceeds is going to reflect a broader issue, much bigger than Palestine and Israel, but the future of the ICC itself. It's stuck between a rock and a hard place, and that's not even getting into the complications. If we were to get into how would this look like, what are the people don't assume that even if they do go to trial, that Netanyahu is never going to be on the stand. And this is not going to be about justice. These will be legal arguments, and legal arguments means kind of like the cases that I started with. We might not even get to questions of the actual merits. We're stuck in questions of justiciability, right? It'll be complicated. The easiest case that the prosecutor will have will be against Hamas, not against Israel, because Hamas weapons technology are so crude as to, they do not have the weapons technology to distinguish between military and non-military targets, which makes them one of the easiest things to prosecute, as opposed to Israel's, violations, which will all be subject to some sort of, military campaigns, fog of war, so on and so forth. That's without even getting into the substance, just on the jurisdictional questions. Okay. The last question was about
evangelical Christians.
Evangelical Christians. Yeah. So let me just answer the question about suing the United States. No. You're not going to sue the United States for a separation of church and state. What evangelicals do in order to build their political power is a representative, that's what democracy does. They're using the space available to them in order to advance their cause. They're organizing themselves politically to do that. It's the same way that all lobbies organize themselves in order to advance their political cause, whether it be the Israel lobby or the, gun lobby, right? They're organizing themselves, and you cannot sue the United States for their political organization. Now, what else do we know about evangelicals is that because of their rise and their ascendance to power, especially under the Trump administration, which takes them very seriously and pivots to them politically, and as much of what it's doing in regards to the question of Palestine is in response to the evangelicals, not even in response to the Israel lobby, tells us that we should be paying more and more and more attention to the evangelicals and more attention to the religious dimensions of the question of Palestine for these populations, where this is the conversation they're having. They're not having a conversation about human rights, or a conversation about settler colonialism, or a conversation about racism, or a conversation about indigenous resurgence, or a conversation about intersectionality. They are having a conversation about the end of days. They are having a conversation about prophecy. They are having a conversation about fulfilling God's goals on earth. And we're not even talking to one another. And so it makes clear for us the urgency to also be having, conversations on that level as well, in order to be speaking that language and to resist it, as opposed to not speaking to them at all, which is frankly, what I've been doing. I've never spoken to them in my discourse, in my book. That's not necessarily speaking to them, but it creates that space of, this is something to be done. This is a community to be spoken to, and I do know of initiatives that do that and that do target them, and it says something about our continuing advocacy and its significance and multiplicity of platforms and campaigns, and the different languages that we should be using to advance the cause. Thank you.
Thank you, Professor Noura Ariqat. I regret that we're out of time, but I wanted to thank you once again for your presentation and informative talk. I invite everyone once again to read Professor Ariqat's book that has been recently published, titled Justice for Some. And for our audience, tomorrow's installment of the webinar series, Day 29, featuring Dr. Mazen Al-Najjar, intellectual and author from Palestine, for his talk titled The Role of Social Formation and Organization in Resisting Colonization. We look forward to having you join once again. And early Eid Mubarak to you and yours, and Assalamu alaikum. Thank you once again.
Thank you, Assalamu alaikum wa Eid Mubarak.